Is California considering a bill that will send children, as young as 12 inches to be sent to group homes without the parents' permission, potentially allowing minors to receive gender-affirming medical or surgical care? No, that's not true. AB 665 is a proposed bill to align two existing state laws that define the circumstances under which a minor 12 and older may seek mental health services without the consent of their parent or guardian. The bill does not call for children to be sent to group homes without parents' permission. Mental health services as defined do not include surgical or medical procedures, and gender-affirming care has absolutely nothing to do with AB 665, a legal expert told Lead Stories. The claim originated in a 10-minute broadcast published by One America News, OAN, on June 5, 2023, titled, "Proposed CA Bill to Remove Children from Their Parents' Homes." A description of the clip read, quote, "California is now considering a bill, AB 665, that would send children as young as 12 years old to group home without parents' permission." One America's Stella Escobedo spoke with Nicole Pearson, a lawyer, who opposes the bill, and is encouraging parents to contact lawmakers. End quote. Below is how the broadcast appeared at the time of writing. Source: OAN. Screenshot taken Thursday, June 15, 10 hours 42 minutes and 46 seconds. Coordinated Universal Time 2023. OAN host Stella Escobedo said during the broadcast that children, in transition, could potentially be taken out of the home without the parents' permission at all, implying that AB 665 would allow minors 12 and older to receive gender-affirming medical or surgical services without the consent of their parent or guardian. However, gender-affirming care has absolutely nothing to do with AB 665. Rachel Velkoff-Hultz, Director for Mental Health at the California nonprofit National Center for Youth Law, which co-sponsored the bill, told Lead Stories in an email received June 20, 2023. AB 665 corrects an outdated legal cross-reference in a phone call with Lead Stories on June 19, 2023. The Office of the Legislative Council of California, a nonpartisan public agency supporting the California legislature, referred Lead Stories to analyses of AB 665 from different components of the legislature. According to its language, AB 6665 aligns the existing laws by removing the additional requirement that, in order to consent to mental health treatment or counseling on an outpatient basis, or to residential shelter services, the minor must present a danger of serious physical or mental harm to themselves or to others, or be the alleged victim of incest or child abuse. At the time of writing, these two pieces of legislation were Health and Safety Code Section 124260, which authorizes those between 12 and 17 years old to consent to mental health services if an attending professional deems them intelligent enough to do so, and Family Code Section 6924, which, in addition to the above requirement, requires that a child must present a risk to themselves or others, or be a victim of alleged incest or abuse. AB 665 strikes the abuse or incest component. If it is voted into law, beginning July 1, 2024, AB 665 would allow those 12 years and older to consent to outpatient mental health treatment and residential shelter services, if a treating professional determines that they are mature enough to participate intelligently. The bill is specific to outpatient mental health care and what is referred to as temporary shelter care facilities. The bill does not prescribe particular interventions or therapies as part of outpatient mental health care. Angela Vasquez, policy director at National Youth Services Organization The Children's Partnership, which co-sponsored the bill, told Lead Stories in an email received on June 20, 2023. Bill does not allow children to receive services other than those related to mental health. Mental health services are defined under AB 665 as the provision of mental health treatment or counseling on an outpatient basis. AB 665 does not change the scope of such services minors may consent to. This does not include a right to consent to medical procedures, inpatient care, or prescription medications, which still require consent from a parent or guardian, Hultz said. Furthermore, the bill does not include gender-affirming invasive medical or surgical procedures under mental health services, which currently require parental consent under California law. Holtz and Vasquez confirm to lead stories. Counseling about gender identity may be allowed under AB 665. Providers are required to contact parents or guardians unless it is deemed unsafe to do so. It is absolutely not true, Holtz said, that a parent would never know what happened to their child, as was stated in the OAN broadcast.